Hi everyone. It's such a pleasure to be here with you today, and it's quite a special thing for me as a PhD student who recently started, as it's the first conference where I'm actually getting to engage with the open source community properly. So I'm an international lawyer by background. I worked recently as a senior advisor to a UN Special Rapporteur, increasingly looking at the intersections between technology governance and human rights. And recently I started a PhD at the University of Cambridge, where I focus on the global governance of open source software, thinking about open source as a digital public good, what are challenges for it, and how we can better protect it and better engage the open source community. Did you want me to get the others to introduce themselves before I kick into my spiel?
I think kick into your spiel.
Okay, I'll kick into my spiel. So what I'm going to speak about today is the broad global approaches and increasing regulation of open source AI. And I feel incredibly privileged to be on this panel because it's very much a global level perspective delivered by myself, then we go to the national perspective with Priya, and then we go to the grassroots and community engagement with Sam. So it's that really nice way to step through the different levels and see how key principles such as community engagement and amplifying the voice of the community play through all three levels. So I'm going to do a comparison between the US and EU regulatory frameworks as it pertains to the development of open source AI. What we're seeing with the rise of AI is this race to develop domestically favourable yet internationally influential standards. And this is not taking place in a vacuum. This happens against a backdrop of overarching governance questions when it comes to open source. And often this is triggered because of increasing cybersecurity concerns around open source, particularly in the wake of Log4j and Heartbleed. In the EU, they are leading on the AI Act, but they're also proposing the Cyber Resilience Act, which some of you, I'm sure, are familiar with. And under the Biden administration, they have passed an executive order on open source software, and there is the Security and Open Source Software Act of 2023, which is currently pending before Congress, albeit held up because one senator doesn't like the act. And until he approves, it's not going to go through. So what I'm going to do is focus on a couple of key trends on US and EU regulation and what are the implications for open source. And the reason I focused on these two jurisdictions is what we are seeing within the broader technology governance and open source space is this increasing risk of regulatory fragmentation. States, the EU, all wanting to do their own thing, set their own terms, and what does this mean for open source in particular, where it's a global digital public good, and having this regulatory fragmentation may in turn jeopardize that and potentially disenfranchise the open source community. I then also consider some of the key implications for the open source community. So a couple of key differences between the US and EU are that the US has more of a hands-off approach to the private sphere when it comes to open source AI regulation. With that Security and Open Source Software Act that I've just mentioned, that would only apply to the public sector. And just a couple of days ago, I read a press release that the US is in fact pressuring for the world's first treaty on AI, the Council of Europe's AI Convention, to enable states to have opt-outs on whether it applies to their private actors or not. And the EU in turn is responding to this and saying, yes, we do want this to apply to the private sphere. But the EU, in trying to engage and apply the regulatory framework to both public and private open source, has been criticised for overreach, most notably with the Cyber Resilience Act. The second point of difference is legal and regulatory uncertainty when it comes to open source AI, and Priya will go into more detail on this. So in the moment in the US, there's a case pending in the Californian courts, those sunny Californian courts, of Roe versus GitHub, and that was a class action that was brought challenging GitHub's Copilot and OpenAI's Codex for taking copylefted code and using it to train their models, but also potentially infringing on those copyleft licenses in the output of those models. So there's quite a lot of legal uncertainty into the US, but by comparison in the EU, at least when it comes to training of these models, there's more clarity because there's an exception within the 2019 Digital Single Markets Directive, which says that when it comes to text and data mining, it is permissible to do so, even though there is copyright material, provided that there is an opt-out from the relevant author or creative. So key challenges that both the EU and US face are how to navigate the relationship between the open source community and other stakeholders. And within the OpenAI context, this also means trying to engage actors who have been accused of open washing, which is an increasingly popular term for describing actors who want to seem like they are acting in the interests of the open source community, but are also relying on open source. And they might do that to further their market advantage or so on. And then the other challenge that both are facing is regulatory fragmentation. So since the EU has a greater degree of regulatory certainty, at least when it comes to the training of these models, some have speculated that there might be a regulatory flight of these AI companies to be more based in the EU as opposed to the US. And this, of course, raises questions for what does this mean for open source and more broadly for the potential fragmentation of governance structures. And to quickly conclude on 2 points for opportunities moving forward, because we want to leave plenty of time for questions from all you excellent people. Firstly, there's 2 common opportunities that the US and EU face. One is ways to improve consultations with the open source community and community engagement in starting to develop appropriate regulatory structures for open source AI. And the second is to try and move towards legal certainty where possible, although this will, of course, be a protracted process, particularly in the US, as the matter is in the courts and may, over the years, work its way up to the US Supreme Court. So that's my spiel, and over to you.
Thanks, Jennifer. I think you've touched on some really interesting points that we'll get into in a bit more detail. And I like that you've highlighted the point around regulation potentially falling behind. I think we can all agree, and how we can make that a little bit more agile. And just to highlight that the AI policy zone is also open today between 1 and 3. And so that's an opportunity for you guys as a community to consult with UK policymakers and regulators. But over to you, Priya, to give some initial thoughts.
Yeah, absolutely. And I will certainly be at that AI policy zone at some point today. Hi, everyone. Very excited to be here. My name is Priya Nair. I'm the IP Policy Counsel at ACT, the App Association. We are a global trade association that supports software developers that implement technologies in multiple verticals. Today, I'm going to give a bit of the small business perspective on open source software and AI and the concerns arising out of the US today, which Jennifer touched on. I'll start with the fact that no matter what industry a small business operates in, they often operate with cost and information asymmetries. And what that means is that these are barriers to competition and innovation for them often. And so reliable, transparent, and balanced laws and regulations very much are a part of key success for them. For small software developers, protecting proprietary code through copyright protection is certainly important, but equally important is the protection of the open source software model. And that's because it allows, through collaboration, the ability to provide high efficiency and low cost solutions to technology development. That's something that's indispensable to small coders, certainly our members. In 2021 and 2022, when generative AI became more public-facing through GitHub's Copilot and OpenAI's ChatGPT, small businesses started realizing, and this is again across industries, new tools to help them fight cost and time barriers. And for coders, for example, GitHub Copilot allowed them to provide efficiencies in the coding process that turns hours of work into minutes and days of work into hours. And again, this is an efficiency that is indispensable to them. And many of our members have said, amongst all the risks that are happening right now, not even in IP, but in security and privacy, they still value using this technology because it is that important to compete in the market today. That being said, there are a lot of risks, and there is a case in the US right now where open source software coders are alleging that GitHub Copilot, OpenAI, and Microsoft are infringing upon open source software licenses. And what do these, I know Jennifer just kind of said this, but what do these entities have in common? Well, GitHub's Copilot runs on OpenAI's Codex, which is an AI program that allows the translation from natural language to code. That being said, I am not a developer, so please don't ask me more detail about that. But I will tell you the legal ramifications that we are seeing. So right now, the court has not decided on if the open source software licenses in question have been infringed. But throughout 2023, when this case initiated, there were multiple claims rooting in copyright law, privacy, different violations that were alleged. A lot of them were dismissed. And the reason for that is because although the coders were able to thoughtfully prove that generative AI can and often does pull from open source software and other copyright protected works, they could not prove that the licenses in question were being infringed upon because of this black box that we often talk about with AI. So that's kind of the first issue that we're seeing. The second issue is that in the US, there is a court-made exception to copyright protection. And this exception is called fair use. There are similar exceptions around the world, although they are different and the courts in different jurisdictions analyze differently, but there's fair dealings in the United Kingdom, there are fair use analysis court-made exceptions all in different states of the EU, I believe. But in the US in particular, this fair use doctrine essentially states that when the use of a copyright protected work is, when denying the use of a copyrighted protected work would be denying something of public interest, then that use would be considered fair use. And there are factors that go into this, but while that's beneficial to the public, what we hope is that this analysis isn't broadened, because if it is, and especially in the case of open source software, it could completely deplete the model, at least in the US. So, what do these two problems have to do with the rest of the world? Well, I think they're relevant to the rest of the world, and that this black box issue is based on the technology, not just the law. And it will affect multiple jurisdictions. The fair use analysis will maybe guide other jurisdictions that have a similar analysis. So that's relevant there as well. So what we're doing for our developers right now is we are thinking about what principles should be adopted in regulation that would support industry as a whole, because oftentimes members of our community, being small software developers, are denied the opportunity to provide input into these regulations, and it dramatically affects them. And so that is kind of my spiel. With that, I'll maybe pass it to Sam.
Thanks, Priya. I think you've given some really good real use cases of how open source technology is providing or giving advocacy to SMEs and allowing them to compete in a very competitive market. And Sam, both Jen and Priya have given some interesting examples of where potentially responsible and ethical data practices are in question. So it'd be really great to hear from your perspective some of the work of Open Data Manchester and what you guys are doing at a kind of grassroots local level.
Yeah, great. Thanks, everyone. Yeah, thanks. Everyone's lovely to be here. My name's Sam. I work for Open Data Manchester. We're an independent, not-for-profit based up in Manchester in the north of England. And our mission is to promote responsible and ethical data practice. We work across the Greater Manchester region, but we also do a lot of work nationally and internationally as well. So today I'm going to talk a little bit about the work that we're doing in Greater Manchester on a much more of a community level, sort of looking at the actual humans, the people who are potentially going to be actually affected by these systems. I think first thing for me to say really is that I think that, data, complex digital systems, AI, they are having a greater effect on our lives. And I think that the narratives around these are all over the place. They veer from, it's going to make everything better, it's going to save all our lives, to it is an absolute existential threat and everything, we need to shut this down. So I think there's a lot of confusion on the ground level. I think that in turn this is leading to poor policy. And as a result, I think we're seeing an eroding in trust, both in policy, but also in just the simple development and delivery of these services that are based on these systems. Just to give a couple of examples, there's policing. Using AI to determine where the most policing is going to happen. All the way up to generative AI being used to do online help desks. You think you're talking to a human, you're not. So. Yeah, as I say, I think it's very, very confusing and for a lot of people, but I think what a deeper level, it can lead to a lack of trust in, our kind of, in everything, in our democratic process, and I think that is a very, very real threat to us. What Open Data Manchester have been doing in Greater Manchester is a couple of years ago, we developed a declaration for responsible and ethical data practice. It was developed over 18 months and released in 2020. It's essentially 23 guiding principles. It was developed with public sector, private sector, academia, charity sector, residents. We all just sort of, we got people together in rooms to have conversations and workshop ideas, and we workshopped a set of 23 principles. You can go to declaration.org.uk if you want to have a look at that. And I think the important thing there was that it was a real collaborative process. It wasn't sort of information silos where the public sector were doing one thing, the private sector were doing another thing. The charity sector and communities were struggling to catch up, It was actually sharing learning, but also developing together. We're actually currently going through a refresh of that at the moment, so we should have a new version of that released in the next few months. And we're also helping to develop principles for automated decision making. These are public engagement principles. This was developed with Foxglove Legal and the Greater Manchester Combined Authority, and it's about how do you properly engage the public when you are thinking about implementing services or systems that use automated decision making. And again, we've done that by actually going and talking to people, bringing people together and working out what people want, what people need, that sort of thing. So we're doing it on a very local level. Again, these are principles. This is a declaration. No one is being forced to sign up to these, but people are signing up to it. The GMCA have signed up to the declaration, various local councils, public sector, private sector organisations, and it's almost like people aren't saying they're going to stick to these rigidly, but they want to do what's right by the people of Greater Manchester, the people for whom these systems are ultimately going to affect. So I think it's really, really good to see residents, public, private sector, academia engaging on these topics. I think it is helping to promote transparency, accountability, people behaving ethically. I do think we have a problem, as it's been discussed here, that the technology is developing faster than legislation can keep up with. I think there's a lot of good sides. I think there's a lot of good sides to AI and the use of AI in automated decision making. There's a lot of bad sides too, and I just think that we need to always ensure, what are we putting first? Are we putting profits? Are we putting whatever? We've got to be putting people first at all levels. So that's it from me.
Awesome, thanks, Sam. That was a great introduction from all three of you, and quite like the point that you made around the cross-collaboration and what you guys did with the declaration. I think it mirrors the collaborative nature of the open source community really well and some of those principles. I will say I've got a bunch of questions that I want to ask, but I will come to you guys, so please do start thinking about questions you'd like to ask of the panelists. And just to note that because the plenaries were running a little bit later, lunch will start at 12:15, so we've actually got a good amount of time to get into some of the detail. And Tam, I really like the point you made around do what's right for the people, by the people. And I think it echoes a lot of what the plenary talks were talking about this morning in terms of, well, how do we shape the future of the community to match those values and those principles? So the first question I have for all three of you is, how do you foresee the relationship between AI technologies and open source communities evolving, especially with the kind of potential legal and ethical conflicts that you've all started to hint at on the horizon?
I could jump in quickly if you want. Yeah, I think I think it is a process that needs to be. I'm going to keep this simple. I just think it needs to be open, and I think it needs to be legible for everyone at all levels. I do think we need to challenge a lot of this black box solutionism. I'm going to use an example that's big in the news at the moment, the post office scandal. It's not about AI, but it's about this idea that technology is infallible. The technology is right, the human is wrong. And I think, if anything, this scandal has sort of shown how incorrect that is, so, yeah.
One thing that I wanted to highlight when we're considering the engagement with the open source community, with regulators, with AI companies, etc., is that on the one hand, yes, states, the EU, they can do more when it comes to consulting and meaningfully engaging the open source community. But they could also look to other ways where the open source community is not necessarily waiting around for these for like a legal decision to be handed to them. They are taking proactive steps to try and get some certainty for themselves and for their community on what this means, and then hopefully feed that information to the regulators, to the companies, etc. And a couple of examples that came to mind were the Open Source Initiative is currently undertaking global consultations to try and define what open source means in the context of machine learning. And in the words of one of the participants, they said very clearly, the reason that we are doing this is we want to define these terms before they are defined for us. So it's having an active role in that conversation and setting that agenda. And another example is the Software Freedom Conservancy. It recently established a working group, a committee that is looking into some of the legal issues arising for particularly copylefted open source, where it is being used and potentially copied in the output of AI-assisted programming models like Priya was talking about before. So there's initiatives that the open source community is taking, it's being proactive, and I think regulators and others could be looking to that and trying to engage them in those processes.
Yeah, and I might just highlight a few things that you said, Jennifer. I think the future of open source software and AI can be really great if industry governs. And you've maybe heard the phrase that governance doesn't necessarily mean government. We do need regulation, but let's let industry define what it means to have transparency requirements, for example. Let's let industry define what it means to take reasonable steps against privacy and security and IP regulation. And that's exactly how you do that, is coming together like communities like this, like conferences like this, talking to like-minded people, gathering input, defining what it means to develop AI and to develop in open source communities and use those tools and talk to policymakers about it. I think it's really as simple as that. It can be difficult because everyone has different goals, but I do think what is unique about the open source community is that there are a lot of shared goals, and that is sustaining the open source software model. So when we think about what regulation should be put in place, we want to make sure that the smallest coder and the largest one, they're both being understood. What concerns do they have? What costs and benefits are there to transparency requirements? What costs and benefits are there to different to accessibility, affordability? Thinking about the industry as a whole rather than just pinpointing what concerns are more publicized right now, I think is a really big point.
Awesome. Thanks, Priya. One more question before I go, unless there are any audience questions. Awesome. Judy, I'm going to hand you this microphone, if that's all right. And we'll start with the gentleman over there. I'm going to switch over, if that's all right.
Thank you. Dominic Connor, Vice Chair, CSTF. One of the things I find, because I do a bit of politics around technology, and I was very interested, so I didn't catch your name at the end. Sam. Sam's point about the idea that this stuff is going to be comprehensible. I actually do code reviews professionally and expert witnessing work. No one can do this. No one can understand these systems. And the Horizon system is actually quite a small and simple system. It was just built by arts graduates. It was just very badly built. And one of the cultural problems we have here is this idea that we have one culture and one set of ethics. I deal with Chinese and Japanese people in my work, people who live in Africa, that sort of thing, and they just are different. But the biggest gap I find, and I include people who politically oppose me at their very soul, is between us and the non-technologists. We actually have distinct cultural values that are not the same as the general population. One only has to look at the toilets that we wander around. You know, I'm fine about that. We're being served vegan food, apparently. That is not the general population. We are culturally distinct, even across countries. So are we going to end up with a world where people like us, because we are mostly, at least to some degree, technology people here, when we are going to be the priests explaining the will of the systems to people, but the rest of the population simply aren't going to understand this stuff, even when we explain. You need to talk to an audience of MPs to see how profound the gap is between technical and people with arts and humanities in how we think. The idea that we respect authority. The level of respect for authority in this room is less than the general population. And so when they come up with these rules, which basically are white people in northwestern Europe and America, the idea that we can impose them on the rest of the world, I think is just a bit ambitious.
Thank you. So I think the question is, how do we find potentially common values across ourselves as technologists and non-technologists? I mean, from my perspective. I'm a person with a STEM background who has worked in policy and spoken to parliamentarians, and often they don't know what we're talking about when we talk about AI and the emerging technologies that we get excited about.
And they think it's good. You've had the flutter above the head, haven't you? The arts graduates go, because they're quite proud that they don't know technology. I'm influenced with such a vast array of things, I won't bore you. But I'm not proud of any of this. The number of people in that domain who are proud that that's only a technical problem. I think everyone here who's worked for a corporate has heard that phrase.
So how do we make it a problem for everyone and not just us technical specialists? Who would like to go first? Sam?
Yeah, I'll do my best. I am someone with an arts and humanities background who also is interested in tech, and I think there's a lot of us out there who actually enjoy sitting in this space and understand the importance of it, working, the effect that it's going to have on people. So I think that, there is, things aren't as simple as that. There is those people who can sit across. And I also think that when I talk about like the principles we're developing, they are localized. We're not saying these are a set of principles that we want to impose upon the world. We're saying this is a set of principles developed by this community that is right for this community. As for like getting people to understand the importance of it or like getting them interested in it, and I think it is my arts and humanities background potentially helps me to engage people in interesting ways. We actually do a lot of stuff with data and weaving and getting people to play with data and explore AI in physical ways that is quite engaging and interesting. So, I think that's how we can do it. But I don't, think that there's ever going to be a one size fits all for the whole world. That's just how we do it in Manchester, Greater Manchester, and it seems to work for us at the moment. So,
I'm going to zoom out from the grassroots, as Sam was helpfully talking about, back to the global level. And the generation of norms and values when it comes to this governance space has been something that I've been thinking about quite a lot lately, particularly in terms of regulatory fragmentation and so on. Because whilst the open source community is incredibly diverse, there's different views, there's different values, it spans all countries across the world, there is a general belief that we are investing our time and our effort into this project for the good of humanity. We want them to have a tool that they can use. We want to impose certain licenses, including copyleft, which mean that others in turn share their derivative works with the rest of the public, really continuing that cycle of creativity and collaboration. But what I'm seeing at the moment within like the AI regulatory space and also looking at regulating open source is states, governments, it seems like they're trying to do a bit of a Boris Johnson for the UK people in the room, have their cake and also eat it. On the one hand, they want to have digital sovereignty, which is a phrase that is increasingly bandied around. They want to be able to set the terms for themselves and have others follow them. They want to be like the EU with the GDPR and have the so-called Brussels effect, where countries around the world look to them and take up their regulatory framework. As I said from the outset, they want to have internationally influential but domestically grounded regulation. But and part of the reason why the EU is doing this is because it doesn't necessarily want to be caught up in the technology trade wars between the US and China. And that is a debate and development that is increasingly affecting open source. For instance, GitHub, largest repository of open source code, but as the US government increasingly put restrictions, including getting them to sanction certain states from accessing GitHub, there has been a response, and China has created GitHe as a response. And this makes you think, like, what does this mean for the fragmentation of open source as this digital public good? And how can we try and reconcile the values that these states are advancing, particularly digital sovereignty, with the digital solidarity that the open source community believes in?
Yeah, I will say it's an increasingly tough question, and I don't think it's something that's truly answerable. Echoing my co-panelists, when you when you approach each jurisdiction, again, laws, regulations, the way they even approach issues are completely different. Like Jennifer had said initially, the US does take a bit of a hands-off approach to a lot of things because they, at the outset, want to see how industry governs and then see what the problems are. Not saying that's always the best way to go, but that is how the US generally operates when approaching these kinds of solutions. I don't think that the international community will agree on a set of principles that specifically target the technology, but I think what they can agree on are principles that support the technology. So, for example, the EU AI Act has a risk-based assessment to AI that kind of gets at, helps align the use and development of AI with standards of equity and efficiency and safety. And these are the kinds of things that are really great and can be implemented, I think, in every jurisdiction in some way, shape, or form. Like I talked about a little bit before, transparency requirements, they may not look the same, but I'm sure that the international community can come together and define guardrails for what that looks like for the technology. Accessibility, enforcement, how are current laws able to support, or how do they not support the technology right now? These very broad principles can be talked about, I think, in the international community. Again, when it comes to each jurisdiction, and particularly for my work, our stakeholder or our members in the UK and the EU have to approach regulation and the laws of their country completely different from the US. But we try to define these broad principles so that policymakers across the world can think about them in terms of this type of technology.
Thanks, Priya. I think we had a couple more questions. Judy.
Yeah, this is sort of asking a prediction about where things are going to go legally. So like with copyleft and copyright stuff and LLMs, you've got one argument that says that these models are trained on this copyrighted material and therefore it's sort of infringing their rights. But you've got another argument that like no one would think that a developer in their 30s who read some open source code when they were 12 learning to program, no one would think that's an infringement. So which direction do you think this is likely to go? And then also, if it gets to a point that like the EU regulates this so much that loads of things that are incredibly productive become illegal, do you think that we might have some kind of like digital version of like the prohibition where everyone is incentive to try and do something illegal because you can get 10x productivity increases? And what would that world look like?
Thank you. So what's the future of copyright, I think?
So that's a really great question. I think each jurisdiction has their own set of issues. For the US, I will say the way copyright infringement is analyzed is often on a case-by-case basis, which is good because open source software is not the same thing as a visual piece of art, right? And recently, the courts, specifically on the fair use defense, have been kind of analyzing this defense very narrowly. And the trend that we have seen, because the Supreme Court just made a decision based on fair use for visual art, it was the Andy Warhol Foundation versus a photographer. And they defined fair use very narrowly because they said you can't verbatim copy and call it your own. And so I have hopes that in the case that's going on right now between the class of open source software developers and GitHub, that the court will say, you know what, we can't call this fair use. Because although there is the black box issue, it would completely deplete the open source software model to call this fair use. Now, the issue is that a lot of cases are being dismissed because of the black box issue. So I think that's kind of where policymakers come in to approach that issue, because when you think about the legal analysis, courts can't really, and stakeholders can't really advocate for their interests and provide sufficient evidence for the court to actually say, okay, for purposes of copyright infringement, this is copyright infringement. Right now, that is a challenge that I think affects every jurisdiction. That's what I'll say about the US. And I'll briefly touch on the EU and the UK, completely saying that, recognizing that a lot of my knowledge is US based. However, we do have stakeholders in the EU and the UK. With the EU AI Act, like I said, the risk-based assessment is really important. I will also say that it is a bit concerning about kind of the high penalties for non-compliance with certain transparency requirements, because general purpose AI is not only developed by GitHub. There are small developers that create this technology. And so we're concerned about things like that. In the UK, right now, the Copyright Design and Patent Act states that the author of a computer program is the one who makes necessary arrangements to create that work. Well, now, in the face of the AI that we have now, what does that necessarily mean? Does that mean that the user of a public-facing generative AI platform can input prompts and that makes them the author of a work, even if there might be infringement involved? We don't know. But I think that's something that the courts are going to have to try to define, or that policymakers are going to have to approach before it becomes a big problem. So.
I wanted to pick up on a couple of things that Priya just said. So firstly, on the US copyright context, the two issues that are primarily at play is one is the training on copyleft materials. Permissible, is it fair use? And I've been reading a number of legal experts in the US who say, yes, it might be considered fair use with the training, but when it comes to the output where it is substantially similar to and copies that copyleft code, that is more likely to be found to be an infringement. But you can go any number of ways and claim, as some have done, that we need to go back and reconsider the fundamental principles of copyright law in some of these jurisdictions in light of the challenges that these emerging technologies are having. The other observation that I had was in the case that Priya was talking about before, the case of Doe versus GitHub in the Californian courts, the judge dismissed several of their claims, including their claim for compensation for copyleft code having been violated. And that was because their specific code that they had actively contributed to, it couldn't be proven that that had been violated. But there's another case that's happening in the US that was brought by the SFC against Vizio, and they are arguing that the group of plaintiffs that can bring these cases, this enforcement for copyleft, should be broadened because copyleft is fundamentally in the interest of the public. So the public should be able to enforce it even though their specific code that they haven't contributed to hasn't necessarily been violated. And the judge has recently let that proceed to the next level, so that's a case to watch and see. On the EU context, it's very much an ongoing conversation that needs to happen as to what are the exact requirements that they're going to put on the open source community. In the case of the Cyber Resilience Act, it was widely panned by the open source community. It said that it went too far. And to their credit, the EU policymakers then went back and said, okay, guys, we messed up, we'll do better, and hopefully there'll be more consultation and engagement moving forward. So it's a bit of a two-way street rather than a one-way highway when it comes to developing these questions and making them as sustainable and equitable as possible. Do you have anything to add on that one?
Awesome, thank you. And we had a question over here.
Hi, thank you so much. My name is Danny and I work at Tech UK, which is the UK's tech trade association. So Priya, I can know some of the issues that you had. Well, I want to touch on this copyright question because I think it's really interesting and it's something that is very much a live debate in the UK right now. The UK has looked and investigated the potential for a voluntary code between the tech companies and the creative industries, and they were unable to come to an agreement. So I just wonder, how do you think that we can solve these tensions, and what is that going to look like, and what questions where do we start, basically, because the government has tried and not really got anywhere, and so a lot of our members are now thinking, okay, well, where do we go from here? So, Priya, I'm looking at you because I'm really curious to hear what your thoughts are. Because, if we're unable to solve this through something like a non-voluntary code, then maybe we'll look to legislation, and that could be, I'm not sure what that could look like and whether we even want to go down there. So, really curious to hear your thoughts on that. Thanks.
Thank you, great question. I think I might come to you, Sam, because I think you've got some very tangible examples of where you have done that cross-collaboration to kind of tackle some of the tensions between data and for public good and then also working with the private industry. So I'll come to you and then come to Priya, if that's all right.
Yeah, I think it is, as you say, it is about, for us, it is about education, bringing people together to talk about these things. I think, I think I said I must start. I think what we often find is a lot of this stuff is siloed, so the different industries don't talk to each other, or they don't. I think that for me is one of the most important things, is to get all voices in the room. Think about who are the people going to be affected by these, and often the people going to be affected by these systems aren't always the people it's intended for either. I think one of the biggest issues we find is that people don't think about this kind of thing when they're costing developing systems. They don't actually think about what is the engagement we need to do around this? Who do we need to talk to? What is the legislation potential? What are the effects going to be? People don't think about these in development. They just go and develop things, and that's great. But people need to start costing that, like user research, into R&D. It's something that I just don't think we see. Yeah, I mean, in terms of the more sort of legal side, the legislative side, I mean, I don't know how well placed I am to answer that, to go too deep on that. But what I will say is, we do see legislation doesn't move as fast as the technology and the effect of technology. So as an open source community, I think it's upon us to be nice, right? And I know that sounds idealistic, but I think that we have to remember that the open source community has been around for decades, but AI hasn't. There isn't like an AI community in the same way as there is an open source one. So I think a lot of it does come down to personal responsibility and personal ethics.
Do you have anything to add? Yeah, I am going to continue to echo my panelists, but my co-panelists, but I will say that that's a big issue that's why I have a job, right? Because it's often really hard to get small innovators to the table. And a lot of reasons why we can't agree on everything is because we're only hearing one side of the conversation. And policymakers are often hesitant because they know that they're only hearing one side of the conversation. And so when you think about what can we do? If you look at the working group for the voluntary code, I mean, they were all large companies, right? So we have to find a way to bring smaller entities that are part of this open source community to the table. And, kind of like Sam said, I mean, AI has been around, but developing a type of community like the open source community has is very valuable. Bringing them to the table is very valuable. These are not issues that have one right solution, but I think in general, it is about providing as much input to policymakers that broaden the scope of what they're thinking about when they think about industry, not just IBM's concerns, right? Like, we need to think about the smallest coder. We need to think about the smallest entity in this conversation. So.
Thank you so much. That kind of calls us to time. I'm going to attempt to summarize that very far-ranging conversation. So we've had a look at the kind of global, national, and local implications of the future of regulation of AI. We've touched a little bit on what those common values should look like, particularly fair, ethical, and responsible use of both technology and data. I think we've all in agreement that harmonization would be ideal, but potentially quite difficult. There's some future trends and emerging cases that we all should probably be keeping an eye on. And some of the challenges around some of the technologies being black box, I think, will make it quite difficult for judiciary or future judiciary decisions. And I think finally, I really like the point you made, Priya, about governance doesn't mean government, and therefore what can we do as an open source community to kind of dictate and define what those values and regulatory frameworks should look like. So I'm going to stop there because it is lunchtime and I don't want to keep you all away from our fantastic vegan lunch. Please join me in thanking Sam, Jennifer and Priya for a really fantastic panel.